Good morning. We are live in the Senate Economic Development, Housing and General Affairs. It is Wednesday, February 21st. It would, I think, be helpful to do a quick round of introductions before we give Senator Hashim the floor. Senator Cummings, would you like to start?
Yes, I'm Ann Cummings. I represent Washington, part of Orange, and parts of Lamoille County. Washington District, I live here in Montpelier. I chair the finance.
Allison Clarkson, Windsor County, Senator, Majority Leader in the Senate.
Keisha Ron-Hinsdale, I represent Chittenden County Southeast. We chair this committee. I'm stalling until my ranking member is able to sit down. We were proud of this committee to pass the PRO Act last year and some civil rights workplace legislation. And we're excited to take this up. Senator Brock, do you introduce yourself?
Sure, I'm Randy Brock. I represent Franklin County and part of Grand Isle County, and I'm the Senate Minority Leader.
And Senator Harrison, who I think is with us.
Oh, there she is.
Yes, good morning. Wendy Harrison, represent Windham District, and my other committee is institutions. And I will be attending remotely today. And I love hearing the chatter. This committee has a lot of energy.
Yeah, especially this morning.
Especially when it's got a room this full.
And we hope you feel better.
Thank you.
Damien, we're gonna have Senator Hashim start so we can go back to committee if that's okay. So you have the floor.
Great. Thank you very much for the invitation. I do appreciate it. And I know that constitutional amendments are not to be taken lightly, so I truly appreciate the time that the committee has taken to review this. And so I'll keep this pretty brief because I know you have a long line of witnesses here today, and I'm sure they can offer a lot more than I can for testimony. But I do have to give a quick shout out to Woody Guthrie, real quick, who 20 years ago, his music is what helped me understand why unions are so important. And then after I graduated from college, I know that I think most folks know I ended up working for the state police for a while. And during that time, I was a member of a union, which really reaffirmed for me how helpful and beneficial unions are to their members. And I'm also grateful to the 20 tripartisan co-sponsors of this bill, who I would also presume are also supportive of workers' rights to unionize. And my goal with this proposal, our goal with this proposal, is to consider the future workforce of our state, and not just 3 or 4 years down the road, but 20, 30 years down the road as well. And the reason that I want to think of them is to make sure that their right to unionize is protected, because we do continue to see increased income inequality while corporations are bringing in record profits, and an increased cost of living across the board. And additionally, we are also seeing health insurance companies raising premium rates, and folks are also having diminished retirement accounts. And I think it's important to note that unions can provide their members with better benefits and safer work environments. And these positive effects on the individual members of the union, I'm confident, will have a positive ripple effect outward into local economies and beyond. And I'm sure you'll hear plenty about that from some of your witnesses. So that is my very brief walkthrough, because I know, and you have a long list of folks who are going to testify today, but I'm really grateful for the opportunity to be the lead sponsor on this bill, and also very thankful to all the folks who are co-sponsors and the folks who will be testifying today.
I feel like I missed the Arlo Guthrie quote.
Woody.
No,
Woody
Woody
Guthrie.
Guthrie.
Oh, wait.
Land is yours.
Okay, I thought we were gonna get like a.
I was looking for a good quote, but I was like, I don't know.
Oh, okay, okay.
It's not
Never
cliche.
cliche.
My first show I produced was about Woody Guthrie.
Oh, really?
I can sing many songs of Woody Guthrie. Don't get me started.
That was beautiful singing. Thank you.
What the?
Any questions? Any real questions? Thank you for bringing this to us with so many co-sponsors. We do look forward to digging in. And as you said, constitutional amendments are not to be taken lightly. But this one starts out with a lot of support, and I think you framed it up really well.
Great. Thank you very much.
Yeah.
Thanks. For the rest of your day.
Go forward and do justice. Okay.
Yeah.
That's right. Right.
Free up your
You're
feet.
busy by the number of ledge councils. I just read and for you.
I can't wait.
Yeah.
Wait,
Yeah.
thank you.
Yeah, that
Listen.
right.
Thank you.
Yeah. Thanks.
Sweet.
So Damien will not be returning to that seat if anything else. Believe it.
He is too popular in too many other. Oh,
Good morning.
Good morning. For the record, I'm Damian Leonard from the Office of Legislative Counsel. So in front of you, you have Proposition 3, or Proposal 3, excuse me. Do you want me to throw it up on the screen? Would that be helpful?
yeah, we have extra copies for you by then.
Great. So the proposal would amend the Constitution to provide that citizens of the state have a right to collectively bargain. As you know, we provided that right for public employees in our state law. And then private sector employees have that right through the Federal National Labor Relations Act. But this would memorialize the right to the state constitution. So the article, it would add a new Article 23 to Chapter 1 of our Constitution, providing that employees have a right to organize or join a labor organization for the purpose of collectively bargaining with their employer through an exclusive representative of their choosing for the purpose of negotiating wages, hours, and working conditions, and to protect their economic welfare and safety in the workplace. And then it includes the language that says that a labor organization chosen to represent a group of employees shall have the right to collect dues from its members. I understand that you're going to hear some testimony later today on that section and whether or not it should stay in the actual amendment if you move it forward. And then it provides that therefore no law shall be adopted that interferes with, negates, or diminishes the right of employees to collectively bargain with respect to wages, hours, and other terms and conditions of employment and workplace safety, or that prohibits the application or execution of an agreement between an employer and a labor organization representing the employer's employees that requires membership in the labor organization as a condition of employment. So the real meat of the provision, you can think of the first sentence as sort of the aspirational goal. And then the meat is the second sentence, which would prohibit this body from adopting any law that interfered with or diminished the rights of individuals to collectively bargain. This would not interfere with federal law in any way. So as always, under the Supremacy Clause, whatever happens with the National Labor Relations Act would continue to govern private sector collective bargaining. But it would just prevent us from adopting any laws that would diminish any rights provided under federal law. And then with respect to all of our public sector employees who have the right, it would prevent us from adopting any laws to diminish their rights to collectively bargain.
I think it's always helpful to remind us the process that a constitutional
Yes.
amendment takes, so that we better understand the effective thing,
Yeah, so it is a long and winding road for a constitutional amendment. So you can only introduce constitutional amendments every other biennium. So this is one of those bienniums. In the first of so it has to take 2 bienniums to get across the line. In the first biennium, it needs a 2/3 affirmative vote in the Senate and a majority of the House. In the second biennium, it needs a majority of the Senate and then a majority of the House that is actually voting. So that means that you could have as few as 76 members of the House, a bare quorum, and you just need a majority of them. And then after that, so that's 4 years down the road now. After that, it's submitted to the voters of the state, and then you need a majority of the voters in the state to adopt it. So it's a 4-year process, finishing with a vote by the general public.
and once it leaves this committee, the language cannot change? Or is it
Once it leaves the
second
Senate,
body?
once it leaves the Senate, there
Yeah.
could be amendments if it had to go to another committee, but it cannot be amended after the Senate, once the Senate votes on it.
Once that language is done, it's not like other bills where you could have like a conference committee or something like that, ironing out differences.
So it would be on the general election ballot in 27, if everything happens.
Yes.
27.
27, so, isn't that right?
26.
I was like,
That
we're doing it odd
fall.
years.
25, 26, right?
Yeah,
General election 26.
Okay.
So we really only have 3 years because we've used up already one.
right. It was only introduced at the very end of last spring. And so you have to get it has to get through both the House and the Senate
This year.
before the end of this year, and then next biennium, you would have 2 years to act on
It
it.
gets rediscussed,
Yes,
although not changed.
that's right. At that point,
Even if the Senate can't change it then.
right, at that point, it's a proposal that needs, like I said, majority votes in both chambers. Although just the majority of those present voted in the House.
And with the language as it is, do you foresee that it requires another stop in another committee?
Excuse me, I do not foresee that it requires another stop. The only thing that I would flag is potentially your government operations committee, because it does affect public sector workers. But other than
A
that,
liaison, so that's good.
yes, other than that, I don't foresee another stop in the Senate. That said, your chamber has the right to think differently than me and refer it to whichever committee it wants, so.
Right,
Yes.
yes, I just wanted to make
Yeah,
sure. I was-
so-
I think just that's you.
But yeah, I could see potentially government operations as a stopping point, so.
And this is a general question, but I imagine this is subject to the same rules of crossover, or if you constitution and.
I'd have to double check on that, I don't
I
don't
don't know if
know.
it does, but
Um,
I think it would be wise to
Of
just
course,
give it more
there's
time.
politics there, but I just wanna, in case we're really wrestling with something before we send it out.
Yeah, crossover was 2 weeks.
Right.
Controversy.
Yes.
Is there anything in the amendment that is contrary to any law that we have in Vermont right now?
So the one thing that I think I would potentially flag here is that it says no law shall be adopted that interferes with, negates, or diminishes the right of employees to collectively bargain. So the question is, are there laws on the books that limit the rights of employees to collectively bargain in a way that they could be seen as being contrary to that? And one of the questions that's come up for me, and I don't know the answer to this, is whether there are certain public sector employees who don't have the right to collectively bargain. And whether this could be seen as providing them with a constitutional right to collectively bargain, although there's no law on the books granting them that right. So traditionally, the way it has worked is whatever's not covered by the National Labor Relations Act, which is state and municipal and county public employees, can be regulated by the states. In this state, we provided rights to municipal and county and all state employees except for employees of the General Assembly. And
We're gonna fix that, of course.
there's actually a bill in the House to do that. So,
I think they're all alone.
but but that's the one question that I would raise is it may raise a constitutional claim that, and if I've forgotten a group of public sector employees, that folks who haven't.
And how will we identify who those public sector employees who might be affected?
Yeah, I think.
Particularly if they're not state employees, but are municipal or.
Yeah, so we already have a Municipal Employee Relations Act and a Teachers Labor Relations Act that covers teachers and school administrators who aren't in a position that would be incompatible with collective bargaining, where they're actually on the bargaining team for the school board or something like that. So we do cover them. I can't think of
County.
employees that we don't specifically cover. So county.
We do have a few kind of.
Their county is covered under Municipal Employee Relations Act. And then also some county, so For those of you who can remember back a few years when the courts decided that our state's attorneys
Right?
office employees were county employees, we've actually explicitly covered them under the State
Right.
Employees Labor Relations Act.
What about fire and police, emergency services?
They're covered under municipal employees labor relations.
Okay,
They have
but
their
can
own.
they strike?
They cannot strike.
That's what I thought. Okay, so
Um,
this would just say they can bargain, but doesn't change.
Yeah, so it says, you shall not adopt a law that interferes with, negates, or diminishes the rights of employees to collectively bargain. It doesn't specifically speak to strikes. Of course, people can always make
I was
arguments,
gonna say, that could be construed as part of bargaining. I
but
don't get what I want, I go on strike. I mean, that's the ultimate.
so I think if you're talking about just the right to bargain.
Yeah.
Over those particular terms. I'm not sure that I would read the right to strike into that. I think you could certainly make an argument that the right to strike is part of that, and there are a lot of folks in this room who I'm sure have opinions on that. But I think when we're speaking about the right to bargain, I'm not sure it goes as far as the right to strike. So the right to strike is recognized for some, but not all employees have collective bargaining rights.
I think we need to be clear on that. Because I just have concerns about risking public safety and stuff. Which is why we have the no strike.
Right, so there are prohibitions on strikes for a variety of employees. We're having employees walk off the job and strike could have implications for public safety or other public services. So that's a policy question and a question of whether you want to specifically provide that this does not include the right to strike. But again, I would defer on a policy issue like that to all of you and to all of the witnesses you're going to hear from as to whether first they see that in here. I'm only one attorney.
Right.
Oh, no, you're one
so-
more than one.
And also what the implications of that are. The other thing that I would highlight in here is just, so it says with respect to wages, hours, and other terms and conditions of employment, we do have a couple of state employees where because of where they are, they follow the non-management bargaining unit for insurance purposes. And don't actually bargain over that. I am not sure the extent to which that would be implicated here, but that's another potential implication. For example, our transport deputies and our employees in the state's attorney's offices just followed a non-management bargaining unit for their health insurance. But again, I would defer to some of the other folks in the room as to how they see that being implicated. But that's another thing that I would just flag if I'm spotting potential issues.
We have some circumstances, particularly with respect to public employee organizations, where people kind of opt out of membership.
So that's.
And does that have any implications in terms of the right to collect dues?
So the right to collect dues is, so this is, we actually have this in all of our public bargaining statutes, the right to collect what we call an agency service fee. The US Supreme Court has held that that's unconstitutional. So that right that's granted by our statutes has not been enforced since that decision, to the best of my knowledge. Because the US Supreme Court said that spending money on union dues is a form of speech, and choosing not to spend that money or to pay that money to a union. And it's important to note that an agency service fee was to pay for the cost of administering, not pay for political activity, but the Supreme Court held that even paying for the cost of administering the bargaining agreement could be considered speech, and so they struck that down for public employees. So my understanding is that you are likely to be asked to remove that clause from this to avoid any concerns about a conflict with the Supreme Court
So
precedent.
that would be the particular lines regarding shall have the right to collect dues from its members.
Yes.
Because they're not really, I'm assuming that the people who have the right under Vermont law right now, not to participate, aren't members of the union, are they?
Right. So that's right. So you have a clear right under Vermont law to join or not join the union. That represents your bargaining unit. And the unions do not have a right to collect an agency service fee from non-members. We do have provisions for dues deduction from payroll and so that sort of thing to allow the unions and their members to make it easier rather than having to write a separate check every month or 90 days or whatever the period is, to simply have a deduction from your paycheck. But this language here, just because of my understanding is concerns to that there could be an argument that it's in conflict with the US constitutional precedent. The feeling is you can take it out and then the unions can continue to collect dues from their members as they have. But we won't run into any arguments that there's a conflict between this and the Supreme Court.
Is there anything in this, aside from that issue, that is contrary to what we do now? Other than, aside from making it permanent from change by future legislature?
I don't see anything here that would be a sharp turn from our existing law. I highlighted a couple of the areas where there could be an argument, for example, where you haven't granted collective bargaining rights to certain groups of public employees, or where you've limited the ability to negotiate over things like health insurance because of the way state health insurance is done. And that, as was mentioned, there's the question too of whether the limitations on the right to strike should be specifically called out in here. So this language was based on an amendment that was adopted in Illinois. So there is some precedent for this, but obviously their laws are different than ours. And so that's something to keep in mind.
What year was that?
That's a good question.
Make us
22. Okay,
What year?
I've pulled the audience here.
22,
So-
20. Oh, just recently.
Yeah,
Has anything, amendment like this, been successfully enacted in any other state?
to my knowledge, these amendments are really new. So I'm not aware of any challenges. At
Is there
this
any
point,
pending challenge?
I'm not aware of any. I will certainly keep an eye out and look into that. But your witnesses may also be aware of it if there are any pending challenges.
It might be good for us to have a witness from the working right.
Up first.
Oh, great. Good job. Good job, April.
Yeah, sure.
Senator Cummings, did you have a?
No, I was just saying, that we were looking at the labor relations with the said, yeah, deputy state's attorneys, I think it's where I should probably with any.
Okay.
So they're already done, and they're under, they're under VSEA, and we're hearing from VSEA. Amy's,
No, there's,
they're on,
I don't know if there are, there's,
Yes.
the deputy state's attorneys are.
okay, because I know there was some mix up when there were cuts and then they were restored, and the state's attorneys did get their salaries restored during the great,
Recession.
yes, session.
Yeah, so a few years back, what happened with that is that they started to organize on a county by county basis. And then we passed a law here allowing them to organize on a statewide basis because they're all on the same state pay plan, even though the court had decided that they were county employees. So it was this sort of a bizarre decision of recognize the location of work rather than the source of payment benefits. And so that we fixed that here with the amendment to SELRA to allow them to collectively bargain so that they could continue to get the same pay and benefits.
Remember,
And the state employees are on our witness.
Yeah, so you'll be able to hear from them. Great,
Okay.
thank you for your time. I know you've got a lot of witnesses. I will log on Zoom and just listen in.
Yeah.
yes, the plus and minus is that you can do that, which takes more time, but now you go off to be another commission.
Well, this is actually my hearing for the morning, so you have my full attention.
Oh, right.
I'll just be listening from my office, so there's a little more,
Appreciate it,
more airspace.
I would say, okay.
So,
Yeah, so speaking of which, we have about 10 to 15 minutes per witness. On the 15 side, and we cut out Mickenberg, but I think he's okay with that because he's always here. But it is nice when he can back clean up, so if you have something to say throughout, that's fine. So I don't want anyone to feel rushed. And if you feel more comfortable, we don't want a lot of solidarity in the room, we don't want to kick anybody out. But if your organization or union speaks and you'd like to leave and chat in the hall or do something else, that's also fine. Since we have so many folks, but if you want to stay, you're also welcome to. I hadn't seen Midwest until now, so we have Sean Stott, who it sounds like is joining us from, is it North Atlantic Midwest region? Is that the NA? North America. Okay.
But based in Chicago?
Springfield,
Okay.
Ah, indeed, love it.
home of Abraham Lincoln.
Indeed.
No, actually, he was born in Kentucky.
One of the homes of Abraham Lincoln, I should say. But we claim
Yeah,
it.
I visited that long, Catherine.
I've seen this one.
Good morning. You have the floor, Mr. Stott.
Thank you. Good morning, Madam Chair and members of the committee. My name is Sean Stott, and I'm the Director of Governmental Affairs for the Midwest region of the Laborers International Union. My office covers all or parts of 10 states, including Illinois, which is where I do the majority of my work representing our 50,000 members. It is an honor to appear before you today to discuss our state's experience leading up to and its experience since passage of the amendment enshrining in our Constitution the protection of fundamental workers' rights. Illinois and Vermont may seem like unlikely legislative companions given our population and geographic differences. Yet, both of our states share a lot in common in terms of their worker protections. Illinois and Vermont, not all states grant the right to collectively bargain to teachers and other public employees. As stated by your legal counsel, both Vermont does and Illinois does. Not all states guarantee construction workers decent wages via a prevailing wage law. Both Vermont and Illinois do. Not all states have a minimum wage law, let alone have increased that standard to nearly $14 an hour. Both Vermont and Illinois do and have. And not all states refrain from intervening in the negotiations between private sector employers and their employees. Both Vermont and Illinois are two of the 24 states that allow workers and their employers to bargain on a relatively level playing field. However, in 2015, Illinois came as close to losing that balance as it ever had. A newly elected governor made right to work for less laws the centerpiece of his so-called reform agenda. This was not something that he campaigned on. In fact, the issue was not something that any nominee for governor from either major party had proposed in at least the last 50 years, if ever. But 1 month after taking office, this governor announced that he wanted Illinois to be a right to work for less state. Despite the fact that both chambers of the legislature were controlled by supermajorities from the opposite party, and despite many legislators from his own party who were strong supporters of workers' rights, that governor refused to sign a state budget until he got what he wanted. For the next 2 years, our state was paralyzed. What spending authority state government had was limited to court-ordered mandates and the rare continuing appropriation. Illinois' bill backlog quickly skyrocketed to $15 billion. Interest debt from late payments to state vendors alone topped $1.1 billion, more than the previous 18 years combined. Our state's bond rating was downgraded a combined 8 times and hovered above junk status. Our social safety net was shredded. This standoff continued for 736 days until July 6, 2017. After the dust settled, the legislature passed a bill prohibiting local governments from passing local laws that restricted the negotiating process between employers and employees. Not surprisingly, that legislation was vetoed by the governor, and despite bipartisan support, an override attempt fell 1 vote short. That legislation was ultimately passed and signed into law by a new governor in 2019. But as we all know, laws can change. Illinois workers' advocates had watched in shock and lent our voices to the protests as some of the strongest union states in the nation, Indiana, Michigan, and Wisconsin, stripped basic rights away from workers at the beginning of the decade. And we were watching in real time in 2018 as neighboring Missouri lawmakers passed identical legislation, only to see the voters reject that law by an overwhelming 2-to-1 majority months later with a citizens' veto referendum. With all of these events and our own experiences still fresh in our minds, workers' rights advocates sought to enshrine this most basic right in our state's constitution. Doing so in Illinois first requires a 3/5 majority vote by both chambers of the legislature and then approval by the voters. The Workers' Rights Amendment not only received supermajority support in the General Assembly, it received 3/5 support among Republicans in the state Senate and a significant share of GOP House members. This level of legislative support transferred to the voters as a whole, as nearly 59% of those who voted on the question in November of 2022 supported adding language that is virtually identical to the proposal before your committee today. It has been 15 months since the Workers' Rights Amendment has become part of the Illinois Constitution, and none of the criticisms of its opponents have come to bear. Workers have not been automatically admitted into unions. I've spoken to a representative of our state's labor board, and organizing among state and local government employees has been no more robust than before passage of the Workers' Rights Amendment. And workers who did not previously have the right to organize under state law were not automatically granted that right. Businesses have not avoided Illinois. In fact, businesses large and small continue to locate here, the most notable examples being 2 private sector investments totaling nearly $7 billion that will create more than 5,000 jobs. Passing a workers' rights amendment in Vermont would not only be a victory for its working people, it would also be a victory for stability. No longer would workers' right to a strong and effective voice in the workplace be at risk of being a political football blown around by the winds from one election's outcome. The people of Missouri spoke decisively on this issue, a state that by no means shares the same political ideology of Vermont or Illinois, but not all states have citizen veto provisions. It took 12 years for the state of Michigan to officially overturn its right to work for less law, which finally took effect just last week. The Workers' Rights Amendment is also a statement of a state's values. It says that a state places a priority on the protection of workers and that they will always have the ability to discuss with their employers issues related to their pay, their benefits, and their safety at work, and do so on a relatively level playing field. Once again, Madam Chair and members of the committee, I am honored for the opportunity to appear before you today. I encourage your body and the House to begin the process of passing the Workers' Rights Amendment and send it to the people where I'm sure it will be approved in an overwhelming fashion. Thank you, and I would be happy to answer any questions.
And did you submit your testimony, Sean, to Magali?
I
To
did.
our committee? Thank you.
Yes, I did.
Other questions?
I love knowing how we're sister states, Illinois and Vermont. Who knew?
I refrain from making the statement that I am actually a New Englander at heart, born and raised, and I've an expat, if you will. So I share a particular interest in this measure.
Right. Thank you so
You
much.
didn't name which state, but that's okay. That might be New Hampshire.
That is
It's okay.
correct.
Okay.
One state to the east.
Yes.
Well, thank you for leading the way on this and helping provide a model from which we can spring. So thank you.
Yes.
Bruce,
Thank you. We might continue to be in touch in case there's any language differences or if people have more questions. So thank you for sharing Eleanor's experience. If it's okay with everybody and if she's ready, I was gonna jump to Elena Bender because she has worked behind his training.
Good morning, just a second. Good morning, everyone. Good morning, Chairwoman Rams Hinsdale and committee member. Thank you for having me this morning. My name is Elena Bender. I'm a registered nurse at the Wyndham Center in Bellows Falls, and I am the Vice President of United Nurses and Allied Professional, Local 5122. I'm here today because I have experienced firsthand the importance and benefits of being able to advocate as a bargaining unit. The Springfield Hospital System has only recently unionized, being certified as a bargaining unit in 2022. I'm from Italy, where unions have been a driving force behind worker rights for the last century. To me, being able to organize and collectively bargaining is an essential right for workers. Coming here 30 years ago, it was shocking to find that workers in healthcare did not have a voice when it came to fair working conditions and retribution. I feel lucky to be in Vermont, where unions are celebrated and supported. I am really proud that since UNAP organized, our relationship with the hospital and various clinics has been positive. When I heard about codifying the right to organize in our state constitution, I did not hesitate. Vermont's culture of valuing workers is something not only to be proud of, but to protect. One reason we decided to organize was because we were not being paid accordingly to the years of working experience. In doing so, we were able to create an appropriate pay scale. There were nurses who had been there for 20 years who had barely received even a cost of living raise, or being paid the same as nurses who had been there for far fewer years. It was really during COVID that we felt the need for a change. We were lauded as heroes, but the real systemic support was not there. Nurses were not being compensated for overtime, working incredibly long shifts, especially in the emergency departments with no break. After the pandemic eased, the recognition really disappeared. Folks were burned out and exhausted. This was the time to organize. It was very challenging to get the union certified. However, I want to be clear that the nurses who are members of UNAP are very committed to the success and health of the organization of which we are part. Our goal is to provide excellent care for our clients as well promote a fair, respectful, and safe work environment. When nurses feel appreciated, when they are well compensated, and when they have appropriate staffing ratio, we are not only less tired and do better work, we are happier. It keeps us longer in this profession. I work specifically in the field of mental health care, and this is a field that desperately needs more provider. It has been meaningful that we are all being more competitively. The impact on our wages was immediate after we formed a bargaining unit. Having a voice through union bargaining was fundamental, especially in a sector where most workers are women, who, when speaking up and standing up for their rights by being direct and asking for what they need, They tend to be labeled aggressive and difficult. Having a formal bargaining unit support me not only as a nurse, but also as a woman. This is a huge advantage because one becomes an active part of a formal process, which achieves one's goals and job satisfaction and form a sense of camaraderie and support with one's colleagues. You cannot be labeled as difficult or have your career threatened because this is a process that everyone understands. Most nurses are women, and the vast majority of UNAP members are as well. The gender aspect and benefit of a union cannot be ignored. Thank you for giving me your time today and for your action on this important issue.
Thank you, Elena. And thank you for the reminder of COVID and, being called heroes, but also deserving the compensation and respect that goes with that. Any questions? Senator Clarkson.
Elena, it's lovely to have you. Thank you. How many nurses unions are there in Vermont? Because I thought there was a statewide nurses union, but you made it sound like maybe they're hospital to hospital.
Actually, I think it's more system by system. I know that UVM has different union, and we go by chapters. We are with UNAP, and even before within a system, there can be different name unions. But we ended up with UNAP, who is that is also a union that covers Rhode Island, Massachusetts, and different New England states. So it depends where you work. It's more of the system where you work.
Thank you. Thank
You're
you.
And
welcome.
we have a list to represent.
I saw
United
that.
Services and Health. Thank you so much. We'll let you get to work and we really appreciate your time.
Thank you for giving me this opportunity.
So I'll go back down the list, but if somebody else has a time constraint to the work, we can also bump you up as well. Otherwise, I'll go to Jocelyn Jones.
Morning, Chair, Graham Hensel, and the members of this committee. It is an honor to be here with you today. Thank you for giving me this opportunity to testify. For the record, my name is Jocelyn Jones. I've been a union side labor lawyer for 25 years, and I'm a partner at the law firm Siegel Reutemann in Boston. We are the largest and oldest union side labor firm in New England. For my part, I live in Northampton, practically a part of Vermont, and I've had the great pleasure of working with unions across the sectors, public, private, and across state lines, basically across the Northeast, including here in the capital of Montpelier. Before joining my firm, I worked as an assistant attorney general in the Fair Labor Division of the Attorney General's office, at times serving as acting chief, deputy chief, Fair Labor Policy director, and in the Fair Labor Division, and had come here at one point in that past interview to testify years ago. So prior to that, I was an attorney at another union side labor law firm and at the former Labor Relations Commission of Massachusetts. I'm happy to be back here before your committee. And before I had talked about testified in particular about misclassification of employees.
So I remember, you testified with.
I did, yeah, I remember you too.
Yeah.
Hard to forget.
I'm so pleased to be here to discuss and support PR3, which, when passed, would mark an important codification of rights for Vermont workers. While this amendment doesn't actually create any new rights, it enshrines existing rights at the moment in history where we find ourselves, and the legal rights of Americans and Vermonters alike being under attack across the country, being eroded by our own Supreme Court. And it's not just our rights in general, but actually, as we know, democracy, voters' protection, and unions are one of the greatest democratic institutions in the country. a place for workers to have a voice, and that efforts to undermine workers' rights, really an effort to take away that power from the people. This trend is very much across the labor world. And in the past few years, we've seen a number of cases that have exemplified this and showing that rights have been curtailed, important rights and rights have been upended that have served to protect workers for generations. To name a few cases, in 2014, the Supreme Court established a right to work, quote unquote, for home care workers and other public sector funded care workers in the case of Harris v. Quinn. In 2018, the court established a right to work for all public sector employees in Janus, and we talked about Janus briefly earlier. In 2021, the court undermined the right to organize by restricting the right to access on employee work sites in the case of Cedar Point versus Hasid. And in 2023, the court delivered a striking blow to unions undermining the right to strike in the case of Glacier National versus the Teamsters. While we see this erosion of workers' rights across the state, we also see the popularity of unions and the power behind unions at an all-time near high. I mean, at a near all-time high. And numerous businesses voluntarily recognizing unions, including our Vermont's own Ben & Jerry's, and even my small law firm in Boston. We were the first ever union-side labor law firm in the country to have an operative collective bargaining agreement with our associates. So we're actually very proud of that. And this amendment, like the amendment you passed recently establishing the right to reproductive freedom, will codify an inherent value of Vermonters. In this case, the right to organize. The importance of having such a right in Vermont's constitution is that it will ensure that it will be protected for generations and workers will be protected for generations. I would like to make one suggested edit to or proposed change to this amendment, and my colleague earlier referenced. At the end of the second paragraph, there's a phrase that says, "The labor organization chosen to represent a group of employees shall have the right to collect dues from its members." I would suggest that this line be deleted. It is actually unnecessary. And currently, all unions must have an operative agreement with their members in order to collect dues. That's a condition precedent. And leaving this line in could raise confusion in terms of how this amendment would be interpreted in light of the Supreme Court jurisprudence, particularly Janus, and potentially and unnecessarily leave it susceptible to challenge. I will note that the Illinois amendment, which my brother mentioned earlier, which this amendment is modeled after, has withstood legal challenge and specifically did not include this line that I suggest be stricken. I would also like to reiterate again, this amendment does not create new rights. It ensures the rights that exist for Vermont workers will not be taken away in the future, just like Vermont did in protecting the right to reproductive health. I thank you for your time this morning. I look forward to seeing the great work that you all do in Vermont in advancing this important constitutional amendment, and highly recommend that you move it forward. Thank you very much.
Thank you. Can I clarify, I'm thinking too personal, but is Sean your colleague, your brother? Did you mean like?
Oh, no, I meant in a like solidarity.
Like
Solidarity.
Very interesting.
Oh, yeah, no, we're not.
Okay.
Related only in values.
I want to make sure, when I heard Senator Cummings asking her questions about the right to strike, I kind of worried that if we try to put it in, we could somehow limit the right to strike for unions that currently have it. Could you kind of clarify if that come up before? And
I mean, the way that this piece of legislation, constitutional amendment is drafted is future looking. It's preventing new laws to erode the laws that are cut away, the laws that exist. It's not giving new rights to anyone. And it's protecting those that exist. And I would just point out that the Vermont Labor Relations Board has and Act and Municipal Labor Relations Act both define what an employee is under Vermont law. So when I read this, this is just enshrining the employees who've already been identified as those able to collectively bargain in Vermont as those that's where the protections come in, the employees who are already employees. It to me does not in any way risk having, people out on strike that don't have the right. It doesn't give new rights, it just protects those that exist already.
So if a new bargaining unit, labor organization comes up to the scene.
Yeah.
Whatever they bargained for would still be protected under this, but the specifics are left out.
Right. If they're legally covered by Vermont law,
Mhm.
they're covered here. And or National Labor Relations Act as well. And any further questions?
Senator.
You mentioned a particular state in which their law, similar to this, was challenged. It did not have, though, a provision regarding dues.
Right.
Was that Georgia? I missed
It
the
was
state.
actually Illinois.
Illinois.
Yeah, right, one chance ago.
Okay.
And so nothing has, people talk about challenging laws and no one has successfully done that in Illinois. And I think Vermont is going to be a leader in this area and that you'll see this same protection put into place in all states that provide.
And it's the states that have this type of protection now, what are they?
That have this new constitutional, I believe there's only one, and that's Illinois. Yeah, is anybody else aware of another state?
There's 4 states total.
Larry, just introduce.
Larry,
Okay.
and I'm with the Building Trades and Labor Union. Hawaii, Missouri now, New York and Illinois. Illinois is just stronger than any of them.
And the others are all constitutional.
Yep, they're all embedded.
Hawaii, Illinois, Missouri, and New York. Have all passed? No, or all proposed?
They're all passed.
They're in the law. Right?
Huh?
New York had their constitution for around our years.
Okay.
They have the right to for variable wages.
Look, you come all the way from others.
I cover out as well as Vermont. Can I?
You can identify yourself.
Mike Marossi with Business Manager, Roofers Water, which is up at 241. Just really quick, I want to comment, and I thank nurses for everything they do. And the nurses organizer in Albany, and again, we're all family here, whether you're a laborer, carpenter, bricklayer, roofer, a nurse.
Legislator.
Legislator, we're all family. Now, this nurse said it really hit home. And nurses, as you may or may not know, even though they get a degree to license the nurse, they still gotta learn on the job. So when they're losing their really good experienced nurses at Albany Med, these unqualified nurses, even with the license, affect everyone in this room. We're all at some day gonna see a nurse. And the last thing I want is a nurse that doesn't know what they're doing. They're in the line of defense. So for them to actually organize and become a union, right? Protected a lot of those experienced nurses that teach the new nurses coming up. So when we're on the operating table, we have the best care we possibly can get. So this not just affects the nurse, it affects everybody in this room. So one day we're all gonna be on the operating table and you're gonna want the best qualified nurse you have to do the work that is needed because they were understaffed and they were not properly paid. So this is how important collective bargaining and unions and fair wages and the right for them to have a voice is for everybody in this room.
Yeah, no, absolutely. I think AFT will probably speak to that a little bit too. But we have had nurses speak directly to us and say they're in tears because they don't know a certain procedure. They want to learn from somebody else and they're being asked to do something that they're not ready to.
Absolutely. Some nurses would have 6 or 7, patients on a given shift, and if they neglect one, they lose their, they lose their license to practice.
Yeah.
They were going 12 hours without a break. A member of mine, wife is a nurse, and she was in tears saying that, 12 hours, and she was leaving other, that wanted to leave to go to other nurses that would pay, hospitals that pay better for their nurses, so.
Mike, I don't think we have you on the list. It sounds like you've come a long way. Is there anything else?
No, the coffee's burning also.
Okay. Good to know, but thank you.
Yeah, thank you for your time, I appreciate it.
Well, thank you for coming. Great.
I'll sit with mine.
Yeah, you're welcome to stay. If you want the next witness.
But
to
you
come
have a
too,
long
but
drive
you might
back.
want to.
I'm gonna stay, just,
Okay.
it's not a fun. I'm
Okay.
gonna sit over there
Okay.
though, thank you.
Thank you for coming up again.
It's
was
my
like-
pleasure.
We're Monday, so clearly.
And it's really nice to see you.
Yeah.
Sorry.
We're getting there.
So next we need to have Alan Rapp from the New Hampshire Unity Table.
Thank you, Madam
Wow.
Chair. Thanks for having me. Good morning, Madam Chair and honorable members of the committee. My name is Alan Raff. Can you guys hear me okay?
Yes.
Okay, great. I'm here on behalf of the New Hampshire AFL-CIO and its 50 affiliate organizations and nearly 40,000 members. I would like to thank the committee for allowing a Granite Sater to come before you and discuss Proposal 3 with you and provide you with the perspective of a neighbor from the East and give you an idea of what working families have to be worried about for the foreseeable future in my state. For the record, I'd also like to state that I'm a proud graduate of the University of Vermont, and I also would like to say how proud I am to have been a classmate of the Honorable Chairwoman. I want to thank her and the rest of the committee members for the work that they do every day on behalf of the people of Vermont. So this proposal will do something for the people of Vermont that my state's elected leaders are unlikely to do for at least another decade. That does not say that I won't be fighting for and towards a future where a similar proposal could become enshrined and recognized as a basic right in New Hampshire, but we're nowhere near as close as your state is to doing something like this that is good for all people from all backgrounds and all experiences. Not only is this good for all Vermont workers, it's the right thing to do because it's an opportunity for Vermont to lead the way as a model for respecting and protecting the right to join together and be fairly compensated for your work. In today's society, almost all of us have to work. And many times we have to have multiple jobs at the same time to be able to provide for our families and try to ensure that they have the opportunities that we have or had. It's just a fact of life. No matter what form that work takes, no matter how old or young or experienced or educated you are, we should all be recognized as having the right to be compensated for our work. The right to property is a fundamental right in our Constitution and our national ethos. Why shouldn't the right to join together with your peers and work together to ensure that you are paid for the work that you perform? It seems like a pretty basic concept, which might be the reason that someone who is being critical of this proposal might say, this is a given, and it already exists in our economic and social systems. We don't need to amend our Constitution for this. And I understand that perspective. Of course I do. But when you really need the work that you get, and the work that you get doesn't pay you what it should, you feel like it should be your right to join with your fellow colleagues and work together to make sure you are treated fairly and adequately compensated for your professional services, whatever they may be. It is an unfortunate fact of human history that many times we don't realize how important a right was until that right is taken away from us by those with the power and the motive to do so. Right now, under your leadership at the state, local, and federal levels, the people of Vermont are being stewarded admirably and, from what I witness, adeptly. But someday, by no fault of your own or the working people of Vermont, this might not be the case. Vermont has the opportunity to make sure that workers now and workers in future generations will have the right to join together without fear of retribution or loss of their livelihood. This is something that I literally lose sleep over year in and year out in New Hampshire. Now, of course, there are always efforts to chip away at the rights of everyday workers by more powerful and wealthy businesses because they're businesses and they're in the business of making money and they want to maximize their profits. And that's not meant as a criticism, it's just meant as a statement. And now the majority of businesses, from small local businesses to large businesses, are not purposely trying to exploit workers. But yet we are all very well aware that it does happen. And depending on the situation, it can ruin a month of your life or decades of your life. But in New Hampshire, without fail, every legislative biennium, the general court will have a vote on a version of right to work. For over 40 years, the legislature in New Hampshire has brought forward an iteration of right to work. And every year, no matter what party has a majority, a bipartisan coalition of legislators have come together to defeat each piece of legislation. I'm sure that the other witnesses will give you a full history on right to work and its insidious inception, but I'm here to talk about the time that my state wastes and the financial fear that people in New Hampshire have to live with every day because they are not protected by things like a minimum wage. There is no state prevailing wage, and their ability to collectively bargain is one of the only tools that have enabled them to ensure that they are being fairly paid for their work and that their family is safe with health insurance and that they're able to plan for a retirement in their later years. It should not have to be considered a privilege to be afforded the opportunity to plan for a future and you and your family that extends further than your next paycheck. Every year, organizations spanning from across the political spectrum waste hundreds of thousands of dollars to argue the value of collective bargaining units and the existence of organized labor in our workplace. Instead of solving issues like our opioid epidemic, we spend money, time, and political capital to ensure that workers can work together to make sure they are paid fairly. Every year in both chambers, as I mentioned, of our legislature, the rights of workers are attacked, and we have to spend months to protect these things that are basic protections for most Americans. For example, every year there are efforts to reduce the time that a worker is able to draw unemployment benefits. This year, we just had to fight off a bill that tried to reduce the maximum amount of weeks of unemployment to 6 weeks. Now, more than any other group of workers in New Hampshire, our public sector workforce has to defend against attacks on their public and on their basic rights. These are the people that keep our state functioning and safe at the most basic levels. I'm talking about our state, town, city employees, our emergency response workers like police and firemen. They spend their careers simply trying to serve the public. But here in New Hampshire, the time that they have outside of the profession is often spent advocating for the rights that they have as employees. Vermont has the ability to protect these workers and their rights for future generations, which will also ensure that they can do their jobs of serving the public for our future generations. It takes courage to be one of the first states to admit a reality that I think we all understand, that workers deserve not only the freedom of association to collectively bargain with their colleagues for compensation, but also that in today's world, these rights need to be protected. Now, my family and my best friends live throughout Chittenden County, and I've gotten to know a lot of Vermonters in the last 20 years. And something that I think all the Vermonters that I know believe is that people deserve to have dignity in their work and should have the dignity of work. This is not thought of as a fundamental right across the border. And that's why I'm urging you to do this, because it is within your power to do so, and that it can be, and with your courage will be, a right that more states feel an obligation to enshrine in their legal infrastructure. This is not about politics or political parties. It isn't about that in my state really either. The New Hampshire AFL-CIO membership is pretty evenly split when it comes to a partisan breakdown. But I will tell you that all of our members understand the importance of what Prop 3 stands for and how important that right is to all of our members, no matter who they voted for president, for governor, or for mayor. They know that every legislative session, they're going to have to take a day off of work and come to speak to their elected representatives about how they deserve to be able to make their own choices about who they can contract business with or who they can work for. I know that if we were able to actually get a constitutional amendment, a CACR, which is the New Hampshire version of a prop, through the New Hampshire legislature, that the people of New Hampshire would vote to add these rights to our Constitution. However, we cannot seem to muster the required number of our 424 member legislature to agree on anything, and these rights are certainly no different. But my probably naive and certainly optimistic hope that as states like Vermont step up and modernize the rights that we consider fundamental, then other states will join in this transition and augmenting of the constitutional infrastructure across the country. And maybe in time, a state that is more similar to New Hampshire than it is to Vermont will make the decision that Vermont has the opportunity to make with this proposal. And maybe by the time that happens, the leaders that we elect to represent our interests in New Hampshire will see that this is a fundamental right for the future of the modern workforce. Although, as you're well aware, New Hampshire is usually the last one to a good idea been in New England. So I'm not holding out too much hope there. But it is my hope that you'll pass this proposal through committee, hopefully unanimously, and that the Vermont will show the rest of the country why Vermont is a special state, because you respect the dignity of all people and all workers. And as fate has it, actually, after I finish this, I'm on my way to the State House in Concord to speak to our representatives about this year's iteration of Right to Work. Because tomorrow, once again, as it has for 40 years, it will come to the House floor for a vote. I thank you, Senators, for your time and consideration and your service to Vermonters, and I'd be happy to take any questions that you have.
Oh, thank you for your work. You're clearly in the right place.
Yes, thank you, Alan. We did indeed start college 20 years ago. But it's just great to see you fighting the good fight in our neighboring state. If we can do anything to help, we will, but it is hard to help New Hampshire.
It is. It's hard
We
when
try.
That's a great
But
line.
it is really great to see you, and thank you for all the work you're doing and for reminding us that what we do does have consequences throughout the country. So,
Yeah, thank you so much for your work and for your guys' consideration. We really appreciate it over here.
Yeah, oh, gosh.
You're welcome to stay with us unless you have to hop off and go to Concord. So.
Thank
Oh,
you.
did you go? Thanks so much, Alex. Okay, next we have Amy Town for PSA. Okay, so your colleagues have left the room, so that's okay. We know where to find
Oh
them.
my God, can I do it without them?
Yes, well, I'm just a woman.
I have no
You're
worries.
behind you.
No worries.
Sorry, I had to get that jab out there. That was not this. Good morning.
Good morning, Amy.
Madam Chair, members of the committee, my name is Amy Town. I'm the president of Vermont State Employees Association. We are a nonprofit, member-directed labor union representing 6,086 members of public sector workers across Vermont. VSEA includes employees throughout the Vermont state government, including the state colleges, Vermont Judiciary, Defender General's Office, State Housing Authority, State's Attorney's Office, as well as the state deputy sheriffs. VSEA is dedicated to the goal of improving the wages, benefits, and working conditions of all Vermonters and state employees. We are so glad to be here today and stand in solidarity with our union brothers and sisters and express our strong support for PR3. This constitutional amendment represents an opportunity for the legislature, but more importantly, for Vermonters to express their unwavering support for the right to organize and collectively bargain in our state, a right that we see as fundamental. When adopted, this amendment will still require the labor movement to do our work and to organize and to service our members. It will enshrine for future generations of Vermonters the ability to do that work. The benefits of labor unions and collective bargaining agreements are numerous. But for the members of VSEA, the main benefit is that it provides us with a voice to express our concerns about the conditions in our workplace. It means that we have the collective ability to work with our employers, in our case, the state and other governmental entities, to tackle the difficulties that we face as a state. I want to thank this committee and the tripartisan sponsors of this legislation for their hard work and for giving Vermonters the opportunity to weigh in on this issue that is so fundamental to Vermont workers. Thank you for your time, and of course, I'm open to any questions.
Any questions specifically for you? Well done.
Yeah.
I like to leave people speak.
You know, when was the VSEA founded?
80 years ago this year.
Why are we not like having a big party?
We are tomorrow, cocktail party, 4:30 upstairs in the cafeteria.
It's tomorrow.
It's
Oh,
tomorrow.
wow. 80th.
It's the same time as Bess O'Brien's movie.
It is.
Oh,
Yeah.
That's okay.
if you have an opportunity to join us this evening, side conversation, and I apologize.
No, I know. Thanks.
So we are having
So what
a
time is
dinner
it
this
tomorrow?
evening
What time is tomorrow?
at 4:30.
Ah,
Our cocktail party and celebration, and then this evening is our safety and security
right,
discussion.
right. That's, and they've been good so far this year. They've been terrific.
Well, thank you. Happy 80 years. Thank you for everything you've done for 80 years. And we might need VSEA back for some specifics, but we never tried too long.
Fantastic.
Thank you for coming in.
Absolutely.
Actually, yeah, I think I've just gotten the sense that there's maybe a new wing of state government that might want to be part of the SDA. Is that coming to us?
I believe it is.
Okay, because we do only have 2 more weeks, so I was gonna ask your colleagues if that.
Yeah, I believe they're working on something.
Is
Okay.
it starting in the house or is it expected to start?
I think it's starting here.
Well, then we need to move on
Yes,
fast.
yeah, that's why I'm trying to
Noted.
say too much, but please do note for them, because
Absolutely.
I don't always catch them at all.
Sounds good.
Okay,
Thank you.
Chris Judy, lunch firefighter.
Thank you.
Thank you for being here, and we will have you back when we take up the firefighters.
Sure.
answer report.
Absolutely. So for the record.
Not meeting because of you.
I'm thinking the first one. That's fine. For the record, Chris Dewey, President of Professional Firefighters Vermont. I want to thank Madam Chair and fellow members of this committee for giving me a couple minutes to speak. My perspective, I don't ever speak, is coming from public safety firefighters. As you know, that when we talk to the National Labor Relations Board, stuff like that, that deals more with public unions. With the private union,
Okay.
we're public, so we don't fall into that. And going back to the senators asking here about the right to strike, public safety can't, we're forbidden from doing that, because it affects public safety. To address that, I don't know if you remember, I think it was 2019, I don't want to divulge too much, but you
passed a law, the binding interest arbitration law. Came through here, that was on the, the request of the DSCA, and they asked us to jump on board, and it was good for us because we cannot strike. So collective bargaining wise, we had no recourse after mediation, where they could basically say, you're taking this contract. That was a great win. We were very happy to get that support. I know from the international level, they love that because it puts us on the roadmap saying Vermont cares about its employees. So going back to this proposal, this is a definite win for labor. Many states have, you can organize, but you don't necessarily have a right to collective bargaining. On the international level, I can speak for the IFF that we, I mean, the IFF have been pushing nationally to have a national collective bargaining bill presented, because there are states in this country where they do have unions, in the South in particular. However, they do not have to sit at the table bargain. So they're basically useless. The federal law would mandate that you don't have to accept a contract, but at least as an employee, you have to sit at the table. Looking at this proposal, this would answer that question here in Vermont. Well, we've been very supportive of labor in Vermont. Wise leader in the IFF, God rest his soul, always preached that you're one election away from losing that. So while we have a very supportive legislature now, 4 years from now it could change, and we could be dealing with what they're dealing with in New Hampshire every year. Right to work is presented. It wasn't maybe 4 or 5 years ago. I remember a flyer around the State House coming out to this group of, hey, you got to do this. So we stand in strong support of this. It's going to help employees across the board. Luckily, the IFF has a strong track record of people wanting to join us. We've been very politically active, but again, we know that there's a lot of states that do not recognize that. There's actually states that have laws that forbid collective bargaining with public safety. So by having this proposal, this amendment, would certainly set us in the right direction. Vermont has been the leader on numerous fronts. I can tell you from my experience, we were the leader on PTSD. A lot of states mirrored their legislation after what came out of the state.
Burn pits.
Yeah,
Other things.
yeah, burn pits, yeah. The chemical exposure monitoring after, you go to a fire and you get exposed, they have to monitor that. We've been on a leader of PFAS, the PFOAs, which is not a whole topic. So it's great to see that we are going to be a leader on this aspect of codifying your right to organize and collective bargain. So with that, I'll leave it open. I'd like to keep it short. If you have any questions, I'm happy to answer. We know where to find you. I love being in this thing.
Well, first of all, we're passing notes because I could not wait. I didn't know we were supposed to wait for a bill from the House to take up firefighter cancer reports, and so we had initiated it. So we're starting that tomorrow, and I don't know if you could be back tomorrow, but
I could probably swing it.
otherwise we'll keep going.
If you're gonna do it tomorrow, I can certainly make it work.
I have heard that. Sorry,
I can make it work tomorrow for you. If you're serious about that.
we're very serious. We'd love to be.
It was in the house a couple weeks ago, and it just happened to show up, and I happened to get this.
Yeah.
What is this?
It's the workers' comp bill that's coming to us from the House, that where it's an appropriate thing to add. whatever.
It's an appropriate thing to add, but I don't want to wait too long to take up the report, because
Yeah, but we,
it's been a
You need to
news
be
item,
informed.
people have
Yeah.
been.
If you got, not to divulge off this
Yeah,
subject,
yeah,
but
right,
if you,
exactly.
there was 2 reports. I don't know if there's the second one come out yet.
I
There was one that was
That's
on
why I
our
wanted to
committee,
talk to
and there's another one that dealt
Okay.
with the actuary looking at
Yeah.
adding all the camps, but I haven't
Yes,
seen that one.
that, I believe that report has come out, and, because Damien and I met about it, so I'm pretty sure it's.
Yeah, no, but we want to know because we're waiting on them, so I think that's why we're starting to.
And off the record, that's one of my long-term goals, is that
Yes.
we'll get that on, but on the.
Yeah.
You're gonna have to stick around for a
Yeah.
bit.
Do you have any questions? Like I said, I think this is a very positive win for
This.
all people, yeah.
Right.
And one last thing I'll say is I know that across the river in New Hampshire, that there are large employers that are anti-union, that actually, I gotta be careful how I say this, but they actually, when they hear the word unionize, because it's a right to work state,
Right.
that it gets kind of funky that they got to push it out. They actually still in their supervisors, the Swelch union. And it's kind of sad because it's one of the large employers across the river from where we live.
Yeah.
And it's, in this, at least in this state, it would be an honor to see this go through, to know that they would have that right to at least talk, that's your right, And the Swelch ad is just
Right.
locally,
Yeah.
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 You know, just because you're afraid of that coming in, and it's been proven time and again that unions don't hurt, they actually help, because they improve workplace safety. On average, 12 to 15% better pay for union versus non-union, better benefits, and helps the economy, because that money is going back into the economy. And I always look at it as, it's gonna hurt, it's not. Businesses are flourishing, you know, I've heard towns, you know, look at my private market, we've grown, we're
You have.
unionized. You know, we've added 10 employees over the last 4 or 5 years, so it does not hurt. It just brings you to the bargaining table. I'm not saying you've got to take the contract, you just got to talk.
Right.
That's all we want.
Right. And even more quietly and politely here in Vermont, we have efforts to stop, unions from forming, et cetera, and being able to have the assumption that it's the legislature has affirmed this right, people in Vermont have affirmed this right, really helps us say, we're starting with the backdrop of, we're supportive of unions.
Yeah, and I could say this from the IFF standpoint, we're bipartisan, we're not strictly,
Yeah.
we work with those who work with us, and I can honestly say in this state, we've had a great relationship from all angles, not just strictly Democrats, but progressive,
Right.
we all come together.
Yeah.
And we've all worked towards a common goal to get there, and it makes it very proud to see that.
Yes. Yes, well, and that reminds me, I haven't asked everybody and it, we can cross this bridge obviously when we get to it, but having unions like yours at the table when this goes to the voters,
Yeah.
making sure it doesn't come across as partisan.
Yeah.
And I'm getting ahead of myself because we have to pass it, but
You're 3 years out.
You are.
I think just, this is a powerful group of people to say that unions are bigger than one party.
Yeah, and I'm
We'll
happy,
have great partners.
Yes.
yes,
That's
that's all.
all with you.
Mecklenburg, and I'm happy I can get people from the international level.
Yeah,
The deal on this nationally, they give you perspective
right.
of what's happening in say, North Carolina or,
Like,
and some of the stories you hear just flat out scare you,
yes.
you know, so.
Then
it's good
I
to
know
get that
Senator
perspective.
Harrison wanted us to talk about Florida at some point and
Yeah.
the scary stuff happening there, so yeah, I think.
Maybe let's stay positive today.
No, it is, that's why I say, again,
She
strong
knows,
support of this
Yeah.
amendment and help you any way we can to get it over the finish line, so.
we appreciate that.
Great.
So we're taking field trip.
And we'll see you tomorrow.
Thank you.
And Heather Weaver from AFT. She knows a thing or two about recent union formation effort.
You're just ever. Go see.
I know. We've been growing a lot. So my name is Heather Beamer. I'm the Executive Director for AFT Vermont. Thank you for the opportunity to testify today. AFT Vermont represents over 9,000 healthcare and higher education professionals in Vermont.
How many?
And not over 9,000 now.
Wow.
And we've
You got
basically
it.
doubled our membership over the last 5 years or so. Our most recent win is actually for 200 staff and faculty at Bennington College. The employer, through a process, agreed to do card check. It took a little while, but we got there, and so we'll begin bargaining a contract there.
Congratulations.
There may be some more coming soon, but we'll.
Right,
yeah.
yeah.
That's the one we're gonna celebrate right now.
Yeah.
That's astonishing.
Yeah. Yeah.
In the last 5 years.
It has, yeah, our last win, and we're doing the first contract for Central Vermont, 500 nurses and techs too. So, sometimes people take the right to come together and negotiate as equals with their employer for granted. But in other countries, it's not allowed. In this country, in some places, in some groups of employees, it's not allowed. And I will say, I think we're one of the few unions in Vermont that represent a significant number of private and public sector employees. And so we kind of, can see the difference in the two. So I'll speak a little bit to that. Before 1935, and then passage of the Wagner Act, there was no legal mechanisms for employees in any sector to come together and negotiate with their employer outside of direct pressure, which usually meant a strike. And in fact, there were a lot of strikes as employees wanted basic safety and health, wanted basic wage minimums. And so the federal government passed the Wagner Act, which provides a mechanism for employees who want a majority of employees who want to bargain with their employer wages, benefits, and work conditions to do so outside of striking. It still doesn't make it necessarily easy. Sometimes there's this belief that there's equal power between the union and employer, and that's what we're working for, but it's very, when the employer uses all their tricks, both legal and illegal, it's very difficult for unions to win elections. Even though we know that all the statistics say the majority of people want a union, that's the barrier, right? The barrier is what's going to happen to me if I try to organize a union in my workplace? Am I going to get fired? And you might, because I will say, employers fire people every day and most people don't know about it, but when they start firing the union organizers, they do. Anyway, so it can be very difficult to win a union. But I also will just say the Wagner Act didn't cover all private sector employees in what, I think is, explicitly a racist move that excluded agriculture and domestic workers due to capitulation to the Jim Crow South. So it wasn't a perfect private sector act. Then in 1947, Taft-Hartley was passed. And that was a real blow in my mind to both public and private sector workers. It said on a state-by-state basis, right now, what we call union security or the right to collect, dues for doing the work, is negotiated, right, in the private sector. And Taft-Hartley said on a state-by-state basis, you can say, you know what, let's say we just, won 200 factory workers, right, in North Carolina, and the employer would be willing to say everybody has to pay their fair share. The union wants everybody to pay their fair share because the union has to represent everyone. There is no separate benefits package, whether you're a member of the union or not. If you're a non-member of the union and you get fired, the union has a legal obligation to unfairly protect. So they said on a state-by-state basis, we can ban private sector employers from negotiating with private sector unions the right to have everybody pay their fair share. So that's what Taft-Hartley did. And that's when we talk about right to work states, and it's a terrible, terrible name. That's what we're talking about. Right to work states have lower wages. They do not have increased number of jobs coming to them. It's just, frankly, a stop to the employers. So switching back over to the public sector side, in Vermont, it took until 1969, 44 years after the Wagner Act, for the legislature to pass enabling legislation for public sector employees to organize. Again, there may have been cases where there was voluntary recognition, but there wasn't a labor board in the process for majority of employees to gain recognition. And then I will just say, and this is something I learned a little while ago, but it wasn't until 1972 that private sector hospital workers had the right to organize. I don't know why they didn't have it before then, but that's when you start to see a lot more nurse organizing start. I did some work in North Carolina for a while, and they had on their books a law that said you can't even join a union. You can't even join it. It's like it would be something like you can't even join, some local social club. That was struck down, but they leave it on the books. But what you don't have the right to do in North Carolina, and there are a lot of municipal workers are overwhelmingly people of color, you don't have the right to bargain a contract with your employer, even if your employer wants to. You are banned from doing that. And so there's a lot of bad things that are happening, I think, in the rest of the country. And I'll just wrap it around. I think, and the last thing I'll say, and people have said before, but I think it's worth repeating, women workers and workers of color who organize see the greatest benefits from organizing a union in terms of the ability to get promotions, in terms of their wages, in terms of fair work. So, I believe it's an equity issue as well. But I'll wrap up there. Both the reasons we think proposal 3 is important and necessary. It doesn't change the status quo, but it enshrines the status quo here and the rights that this legislature has already given to workers in the state.
Thank you. And I appreciated the gender parity in our witness list. I don't know the last time we had 4 women and 2 people of color on the labor committee in the Senate. So that point is not lost on us, and we appreciate that. And we appreciate that you have started to organize some of the most diverse, least represented workers in the state. Some more of those companies.
Academia and thought.
Yes. Committee and members, we are doing quite well on time. And I'm wondering if we often don't get employment breaks here in the
We get,
legislature.
no, we're poorly paid and we get no breaks.
I'm wondering if we could come back at 10:45 and if everybody's okay with that.